afternoon, everyone. We have been advised that Her Excellency Paula May Weeks, Order of the Republic of Trinidad and Tobago, hereinafter referred to as ORTT, the President of the Republic of Trinidad and Tobago, and Dr. the Honorable Keith Rowley, the Prime Minister of the Republic of Trinidad and Tobago, and Mrs. Rowley, will be joining us later in the proceedings. The Honorable, the Chief Justice, Mr. Justice Ivor Archie, ORTT, Chief Justice of the Republic of Trinidad and Tobago, and Mrs. Rodriguez Archie, the Honorable Bridget Anizet George, Speaker of the House of Representatives of the Republic of Trinidad and Tobago, members of Cabinet of the Government of the Republic of Trinidad and Tobago, Your Excellencies, the heads of diplomatic missions, judges and judicial officers of the Supreme Court of Trinidad and Tobago, Madam Justice Isabella Ferrari, Brazilian federal judge and the 2021 Distinguished Lecturer, members of the Senate, House of Representatives, and the Tobago House of Assembly of the Republic of Trinidad and Tobago, members of the Board of the Judicial Education Institute of Trinidad and Tobago, the JEITT, retired judges and judicial officers of the Judiciary of the Republic of Trinidad and Tobago, representatives of the Caribbean Court of Justice, representatives of the Legal Fraternity of Trinidad and Tobago, distinguished representatives of the state and private sectors and academia, representatives of the Court Administration of the Judiciary of the Republic of Trinidad and Tobago, members of the media, all participants, welcome to the 9th Distinguished Jurist Lecture 2021 series. I hope you enjoyed looking at all the slides in the pre-event show, and I'm sure that you got all the Q&A multiple choice questions and answers correct. The host of our lecture this afternoon is a highly accomplished legal luminary whose CV, which highlights his qualifications and achievements, has been shared with you as part of our pre-event. This introduction, therefore, focuses on the visionary leadership of our host, the Honorable, the Chief Justice, Mr. Justice Ivor Archie, ORTT, who continues to navigate the judiciary with distinction through the waters of change. The Chief Justice's scientific mind and legal acumen provide a powerful combination that has enabled the judiciary to become an enhanced service provider committed to widening the streams of access to justice and procedural fairness. These tenets have always been close to his heart, as evidenced at the opening of the 2011-2012 law term, that is a decade ago, when he said, and I quote, "The notion of access for all continues to drive us in the judiciary. The core value of access to justice is therefore at the center of our vision. The commitment to accessibility has profound implications for the way in which every organ of the state sees its role, and in the context of a rapidly evolving technological environment, forces us to move beyond our traditional province in the provision of services. In other words, we must become a high-performance professional organization. So timeliness, efficiency, and attracting public trust and confidence are not just feel-good objectives. They are our raison d'etre." End of quote. I shared this excerpt because it best describes the vision and mission of the judiciary under the stewardship of our host, the Honorable Chief Justice. And it further places in context the relevance of the lecture this afternoon, which deals with artificial intelligence and its practical impact on the law. In an era in which innovation, diversity, and the use of technology are the hallmarks of successful organizations, it is imperative that leaders motivate the members of their organizations to confidently embrace the new environmental working space and place. Here again, our host, the Chief Justice, is consistent with his shared vision of organizational transformation, as stated in his most recent speech at the opening of the 2020-2021 law term. And again, I quote, "A rapidly changing external environment tests survival fitness and places an evolutionary pressure on any organism. It is not so much about what we want to be, as it is about how we want to be. Flexible, agile, and relevant, end of quote. Wearing the cap of President of the JEITT, the Chief Justice, through active networking and global presentations, has forged partnerships with stakeholders who assist in making the JEITT an institute that is a forerunner in judicial education. The fact that this lecture is open to all our local, regional, and international stakeholders and members of the public, including students at the 3 regional law schools, is indicative that our host, the Honorable Chief Justice, is an intellect willing to share expertise and resources for the overall advancement and upgrade of the administration of justice. It is therefore my privilege to introduce the host of our 9th Distinguished Jurist Lecture, the Honorable the Chief Justice, Mr. Justice Ivor Archie, ORTT, Chief Justice of the Republic of Trinidad and Tobago and President of the JEITT. I thank you.
Thank you very much, Justice Lucky, for that very, very generous introduction. Since the protocol list has already been established, it remains only for me to thank you all who have logged in to join us. We are very honored that you chose to devote this time. My task this evening is both to introduce our featured speaker as well as the topic. Because we have a very mixed audience, I thought it might be useful to give some context to what will follow. It is not often that I see a spark of interest when I talk to lawyers about artificial intelligence or AI. Many seem to think that it is some esoteric technology that is of little relevance to their work, although I do suspect that there may be a generational divide in that regard. In fact, the technology is ubiquitous, and we often miss how heavily dependent we already are on it. Every time we do a natural language search on Google and get results ranked by relevance, we are employing AI capabilities. I know we all get irritated by the fact that every time we look for something on Amazon, shortly thereafter, we are inundated with ads for similar items. And then, of course, there are what are now some more mundane applications, like the face recognition on your phone and Siri and Alexa following all your voice commands. So, what is this thing that we call artificial intelligence? One of the hallmarks of human intelligence is the ability to learn by observation, pattern recognition, classification, and error correction. Human beings are also capable of abstract creative thought, which is what makes us adaptable and able to deal with novel situations. The holy grail of AI, therefore, is to build machines that are capable of higher level executive functioning, that can turn their hands to any task just like a human being, instead of being capable of only one specific and narrowly defined task. Much of the technology has been around for quite a while and is only now progressively finding practical applications. And while we have not attained the ultimate objective, considerable progress has been made. Permit me to illustrate. The practical manifestations of some early forms of applied AI, and think in this regard of Siri, turn on the lamps, or Alexa, play Whitney Houston, they demonstrate little or no creative ability. They are designed for specific tasks using narrowly defined rules and objectives. So, even when Deep Blue beat the world chess champion in 1997, it relied on customized hardware and narrow algorithms to generate and evaluate millions of positions. This was assisted by interviewing selected grandmasters and trying to code their wisdom into the decision-making trees. However, the decision pathway was defined by the programmers. However impressive, this was still a brute force approach. Fast forward to 2015, when AlphaGo was simply given the rules of Go, and some of you may know that Go is a game considered far more complex than chess. AlphaGo played itself and after 3 days was able to defeat the Go champion. This is true machine learning, where the machine does the observation and classification, and the decision model is determined by the contents of the input data. Pay attention to that last sentence because it's very important to our discussion later this evening concerning the strengths and weaknesses of AI. This is achieved by a neural network approach which, as the name implies, deliberately mirrors the architecture of the human brain. Instead of using lots of rules, you simply feed it lots of examples and let it figure out the rules for itself. If you think about it, that is how we learn as infants. So, what, I know you may be asking, does any of that have to do with the law? The fact is that AI is already impacting both the substantive law and the way that law is practiced. In the civil arena, for example, liability issues are rearing their heads in regard to the imperfections in software for self-driving cars, tumor diagnosis, and due diligence in commercial arrangements, just to mention a few. In the criminal arena, there have been wrongful arrests based on flawed facial recognition technology. Sentencing and bail risk assessment tools have arisen and been discredited. Not surprisingly, these have often operated to the disadvantage of minorities or persons from certain socioeconomic backgrounds. In both the civil and criminal spheres, deepfake technology is calling into question the reliability of video evidence. It is not that these technologies cannot be useful, and it would be fruitless to wish them away. What is required is a massive adjustment in how we educate and prepare lawyers for practice or for the bench. We need to have sufficient understanding of how the technology works to be able to assign responsibility or to interrogate the weight or value of evidence and not simply accept it because it is quote unquote scientific. Let us look at some examples of how law practice is already affected. E-discovery. Artificial intelligence has been introduced into our workflows. If we have thousands or millions of documents to review in a case, it has now gone beyond just typing in keywords to reduce the pile. Machine learning can assist us in determining relevance. At the other end of the continuum, should we advise clients without at least considering the predictive power of algorithms? In one study, when fed the facts of cases before the US Supreme Court, AI was able to predict the outcome 86% of the time versus 66% for practicing attorneys. In reviewing material already identified by document searches using AI, legal analytics have now enhanced our ability to identify relevant elements and issues in a particular case or transaction. It replicates how lawyers learn over time, which is by reading many examples, except that it is far more efficient. To take yet another example, one study testing the ability to identify errors in non-disclosure agreements found that in terms of accuracy, AI beat lawyers by a 94 to 85% margin. The kicker, though, is that what the lawyers took on average 92 minutes to do was done by AI in 26 seconds. And finally, many firms are now providing automated online legal services. So, for those of us who confidently say that AI will never replace lawyers, the news is mixed. Of course, there will always be a role for lawyers, but we are going to have to find the ways in which we can add value more effectively than AI. It does mean that the structure of law firms will probably look very different in 10 or 15 years' time, if not sooner. With those observations, it may be a convenient time to turn to the main focus of this evening's lecture, which is the application of law, or the application of AI, beg your pardon, particularly in a judicial setting. And just in case the judicial officers among us are feeling smug at this point, let me remind you that millions of disputes are being solved online every year. eBay alone resolves tens of millions of disputes every year, and the service is free unless you want to pay $15 or so for a trained mediator. Turnaround time is 5 to 7 days, and satisfaction rates are upwards of 95%, with a right to appeal preserved. It is therefore not surprising that many jurisdictions are looking at online dispute resolution as a cost-effective and efficient way to resolve low-value claims. That is a conversation that I intend to have locally, especially in the context of the overriding objective of our civil proceedings rules. And just to remind us, for the non-lawyers among us, our civil proceedings rules mandate us to save expense, to deal with each case in ways that are proportionate to the amount of money involved, their importance and complexity, and with expedition, all the while allotting to each case an appropriate share of the court's resources for which it is competing. This lecture is both for general information and interest, as well as an entry point into what I hope will be a national discourse about the way forward in our continuing quest for solutions to the challenges of delay and improved service delivery. In that regard, I am therefore privileged to introduce our featured speaker, Justice Isabella Ferrari, who is a federal judge of the Federal Regional Court of the Second Region in Brazil. Judge Ferrari has been a Brazilian federal judge since 2012. She was previously a federal public defender from 2009 to 2012. Judge Ferrari was a Harvard Law School visiting researcher in 2016 to 2017. She holds a master's degree from the University of State of Rio de Janeiro and is currently a PhD candidate in the same institution, where she researches on topics such as law and technology and algorithmic accountability. She's an advisor for the Future Society, which is a nonprofit think and do tank incubated in the Harvard Kennedy Law School of Government. I beg your pardon, Kennedy School of Government. She is a member of the UNESCO Information for All Working Group and is the senior lecturer for the module on online courts for the upcoming UNESCO AI and the Rule of the Law open online course for judicial operators. She is also the academic coordinator of the New Law Institute. Judge Ferrari is an international lecturer and professor and has published several books on the digital transformation of legal services. On a personal level, Judge Ferrari is passionate about two things, ballet and education. She dreams of transforming the way that law is taught in Brazil towards an approach that really addresses the severe problems her society faces, and you will hear about some of those challenges this evening. I have had the privilege of presenting alongside Judge Ferrari and can attest to her deep knowledge and practical understanding of this subject. I hasten to add that on that occasion, she was very much the star and I was the supporting actor. Since she is the real expert, she will therefore be the one answering the questions at the end of the lecture. I will try to ensure that we cover a reasonably wide range of interesting and relevant questions in the time allotted. Thank you for your patience, and I now turn you over to our distinguished lecturer, Judge Isabella Ferrari.
Thank you so much, Chief, for the kind introduction and the kind invitation. The Honorable, the Chief Justice, my friend Ivo Arti, ORTT, honorable judges, distinguished participants. Technology is reframing the way we live. It's changing the way we connect, we work, we play. Many important decisions historically made by humans are now being made by computers. And with the legal system, things couldn't be different. Law is changing in an increasingly faster pace. If we take a look at legal firms, we're going to see how technology is changing their scenario. We have now AI tools drafting petitions. We have data analysis defining baselines to agreements. We have jury metrics being used as a tool to make more accurate predictions on the time of the lawsuit, on the result of lawsuit. We have legal operations there's applying technology to manage law firms. We have new ways of communication between lawyers and judges through visual law. So legal firms are adopting technology to gain efficiency, to gain speed, to make more accurate predictions and get better results. But tonight, we're not talking about law firms. We're talking about a not so silent, but indelible trend. We're talking about the digital transformation of the judiciary. Digital transformation that is being seen as the answer for problems regarding the increasing litigation that we face due to the hyperconnectivity of the societies we live in. Digital transformation that is being seen as an answer to the backlog that judiciaries all over the world are facing. Digital transformation that is being seen as an answer to the new challenges posed by the pandemics. So tonight, what I intend to do is to show through concrete examples what technology can do to foster rule of law values such as accessibility, consistency, efficiency, and fairness, while it makes the lives of judges, lawyers, and parties easier. As nothing is 100% good or bad, we're also talking about the safeguards that we must take to ensure that this movement of digital transformation is successful. Tonight, we're talking about the rise of online courts, one of my favorite topics. And I intend to answer with this lecture to 5 fundamental questions. First, what is an online court? Second, how do they differ from courts that simply operate online? Third, what exactly are online dispute resolution systems? Fourth, how can we adopt artificial intelligence tools to help judicial operators? And fifth, what are the pros and cons of the online courts movement? So let's start with the first question. What is an online court? It's important to understand that online courts are much more than courts that simply operate online. When you talk about online courts, we're talking about a movement that is not only bringing courts to a new space, but especially is rethinking the way we offer justice and the way we handle conflicts. There are two pillars built in the idea of online courts. The first one is the adoption of online dispute resolution tools. The second one is the use of AI tools to assist judicial operators. We're talking about the two of them. We start with the first pillar, online dispute resolution systems. Online dispute resolution systems are digital spaces where parties can convene to resolve their dispute. The inspiration to online courts comes from the private sector, where platforms such as eBay, PayPal, Alibaba, and Amazon decided to create their own resolution tools, their own dispute resolution tools. What happened? They realized that one of the difficulties people had to use their services regarded the fear they felt that having a problem, they wouldn't be able to solve it in an easy way. So they thought that to convince people to use the new services they were offering, the new online services they were offering, they would need to offer an online dispute resolution tool. When we look at these tools, we realize that they operate in similar ways. We are usually talking about building blocks that address specific characteristics of the conflict. So the first thing that usually happens is that these online dispute resolution systems provide information to the users. When you have a neutral source of information, when the two parties receive the same information, you have, as a result, you reduce the asymmetry of information, and then you put the parties at the same page. Doing so, you align the expectations. They have similar expectations, what makes it easier to get to a consensual agreement, to get to an agreement. So you open the negotiation window when you provide this information through a neutral source. After you provide information, these ODR systems usually allow parties to negotiate directly. Remember that they are now on the same page, so it makes it much easier to get to an agreement. If the parties can't reach to an agreement by their own, you go to the third phases, phases of online mediation, where a human or a software suggests baselines to agreements. If it's not enough to solve the conflict, you go to a fourth phase of decision or adjudication that might be done by a human or a software. Usually, these platforms allow that the execution of the decision occurs immediately. They usually have the credit cards of its users and the authorization to use it to enforce the decision that has been taken. ODR tools in the private sector have been an enormous success, as highlighted by Chief Justice Archie. eBay, for example, decides through its online platforms more than 60 million disputes a year, with a rate of success that exceeds 95% of its users. So even those who lose the disputes, they feel that justice was done in their case. Looking at this situation, judicial operators, pressed by the increasing litigation and backlog, started to reflect upon the way of adopting online dispute resolution tools inside their own field. And that's how the online courts movement started. So when we look at the movement of online courts, we realize that it usually starts upon the countries in the following way. In the first moment, some of the acts that were done offline start to be available online, such as filling or responding petitions, doing hearings, etc. And of course, the pandemic gave traction to this trend. In my view, and I think this is important to say, courts that are simply available online, they're not properly online courts yet. They are just duplicating the activity from one kind of environment to the other one. I talk, and I think we should talk about online courts only when data analysis is added to the game, helping case management. For example, when you have a system that is making predictions regarding the time of the lawsuit or the rate of success of the demand, when you have a system that's offering legal information to its users based on their analysis and other situations. It's important to realize that in online courts, technology plays a very important role in pushing agreements. Strategies like providing information and letting the parties negotiate their conflict directly or make them go through mediation before adjudication are important to reduce the backlog that overwhelms the court systems. In online courts, new ways of communication between the parties and the judge are usually officially allowed, such as email, WhatsApp or similar apps, and video calls that might be used to do hearings, for example. Now I want to show you a case study that is a groundbreaking reference when you think about online courts. We're talking about the British Columbia Civil Resolution Tribunal. And I'm showing you some slides that have been produced by Shannon Salter, its chair. Here we can see the CRT dispute resolution system. And you can perceive that the system is designed in a way that it aims to solve the conflict in the first moment that it's possible. So you're always avoiding that the dispute continues. You're always encouraging that agreements are taken. So you're always trying to prevent that the conflict escalates. So the first moment you give information to the parties, you help them understand the situation, you provide self-help to avoid the dispute from emerging. In the second moment, you allow the negotiation to avoid that a case is filed in British Columbia CRT. If you can't avoid this, you'll try to avoid adjudication. So you facilitate the negotiation through ADR and hearing preparation. If you can't avoid adjudication, you'll try to avoid that the trial is inefficient. If you can't avoid that the trial is inefficient, you'll try to avoid inefficient enforcement. So as I told you, you're always trying to prevent the conflict from escalating. In the next slide, you're going to see the structure of the British Columbia Civil Resolution Tribunal that is organized in 3 phases. The first one is the Solution Explorer. This is a free phase. Anyone can try the Solution Explorer. The second one receives the name of the court, the CRT, the Dispute Resolution Tool itself. And the third one is the adjudication phase. The most interesting one is the first one, the Solution Explorer, because it shows us the way and the resources we have when we adopt online dispute resolution tools in the judiciary. So I'm going to show you a little bit of this phase. The next slide, you're going to see that when you log into the court, the online court, you see a video stimulating the parties to try the Solution Explorer. You can realize that they have a they are really worried about making something that is user-friendly, making something that anyone can understand. And this happens because in the British Columbia CRT, lawyers are forbidden, so you can't be represented by a lawyer. In the next slide, we start to see how the online court provides information to the parties. So it asks a series of questions to better understand the conflict that is bringing that person to the court. So ready to start, click on the button that best describes your problem. You have a problem with employment, with insurance, with loans and debts, and then you go choosing and teaching the system about the problem that you have. The next slide is basically the same thing. So the person has chosen, you have a problem with goods or services. The next slide, after you say whether you're a buyer or a seller. So you first told the system that you have a problem with goods or services. Then the system asks you, are you a buyer? Are you a seller? And when you check on the box of the buyer, the system asks you, we're going to ask you some questions about your dispute so we can give you the right information for your situation. First, why did you buy these goods and services? For personal, family, or household use, for business use, for something else? So asking these questions, the system can understand your situation and give you legal advice. For example, if you bought it for personal, family, or household use in Brazil, this is something that would make the consumer law applicable to your situation. And the rules are different from the ordinary rules of law. So that's how the system can provide the information to the parties that are using the Solution Explorer. But the Solution Explorer is more than just providing legal information to the parties. In the next slide, you're going to see that after understanding the situation, the system also helps the parties, providing them pre-written notices or emails or documents. They have models that the parties can easily adjust to their situation. So this is the example of a pre-written letter to report a problem with travel services. So you can see that everything is organized to make the life of the parties easier and to make it easier to be able to enforce your right. It's important also to perceive that when the other party of the conflict receives a letter such as this one, the first thing that the person will think is that the other party has already used the Solution Explorer, has already understand that she has a right to something, and is, by noticing the other party, is already starting the procedures that might end up in a CRT case. So this is another factor that might push an agreement. If a party starts a CRT case, it will end in 60 to 90 days maximum. So when you receive a pre-written notice like this, and if you know that you're wrong in that case, you tend to decide or to try a kind of agreement. So it's not only about providing information, it's also about helping with documents, with providing the necessary documents for a case. But more than that, in the next slide, you can see that the CRT also has available a workbook for negotiating a solution. So it's another resource that is used to help parties, to empower parties to get to an agreement. So this situation show us how these tools can take an approach that is much more complete sometimes than the ones that we can give in the bench. I have around 5 hearings a day. I have friends that have more than 30. We don't have time in the beginning of a hearing to tell the parties the importance of negotiating or to give them tips about negotiating. This is something that an online court can do. So in the next slide, we can see that when we adopt online dispute resolution systems in courts, we might give a more holistic approach to conflicts. And the holistic approach comes from the automated legal advice that parties receive, from the document orientation that they have, from the fact that that technology is used to push agreements, given in the first moment information, and then trying to push agreements through mediation. And we see that online dispute resolution systems in courts also allow new ways of communication that makes the parties' lives easier. And when we talk about the benefits, in the next slide, Professor Orna Rabinowitz-Aini, she highlights the fact that the online allows a better accessibility with a lower cost and more simplicity. And she also highlights the role of technology as a fourth party on the conflict. So the same way as we have the parties and the judge, technology plays a very important role in giving legal advice, as we've seen, in pushing through efficiency, in helping documentation and design. When we talk about ODR in courts, we just can't forget that we need to pay attention to some important concerns. The first is digital divide. Digital divide is the gulf between those who have access to computers and internet and those who do not. Solving or reducing the digital divide demands a multiple stakeholder effort that should involve the judiciary, the executive branch, the legislative branch. And the second concern, of course, is cybersecurity. we need to guarantee, if we're trying to establish online courts, we need to guarantee the availability and the integrity of the services. Here in Brazil, we have electronic procedures since 2010, and last year we had a huge problem with the availability of the services of one of our most important courts. They were attacked. The Superior Court of Justice in Brazil was attacked by a hacker, and its services were off for 1 week. Only urgent matters were decided by the chief judge. Integrity of the services also is a concern. We also had a problem with this some months ago when a hacker invaded the systems of one of our courts and changed the decisions of the judge. So availability and integrity must be a concern when we are trying to do this movement of bringing courts from the physical space to the online one. And now we're talking about the second pillar of online courts, and the one that I prefer, AI tools to assist judicial operators. So though ODR is usually where countries start their internal movement towards online courts, they are not the only pillar of online courts. Online courts advance to another level when they start to adopt artificial intelligence to assist judges in their decisions. When we talk about AI decision-making in the judiciary, we can listen to what Lawrence Solon says about it. He says that in legal systems, AI might be adopted to, first, provide non-binding recommendation to human judges, such as suggesting precedents that might be applicable, such as drafting decisions. Second, provide judgments that must be followed unless the human judge provides a legally sufficient reason to override the judgment. And third, replace human judges in some cases, and we're talking about this later. When we talk about AI decision making in the judiciary, we can pay attention to some examples, some important examples that we have in the world. I brought to you 3 countries that are leaders in this scenario. The first one is Brazil, where we have some important tools. The first thing that I wanted to highlight is automation. Automation is not exactly AI. When we have artificial intelligence, you have an intelligent decision. A decision is being taken. When we're talking about automation, we're talking about things that must happen, that will happen always in the same way, but that might be really helpful. When I became a judge in 2012, we already had an electronic system. But in this first version of the electronic system, every time that I decided something, I needed someone of my team to log into the system and to make a movement to publish my decision. And then I needed another person of my team to log in again and then to make a movement to get the party summoned. But think about it. If I decided something, of course the decision must be published. Of course the parties should be summoned. So in the second version, this is automatically happening. This might help a lot the daily lives of judges and civil servants. The second interesting tool that we have regarding AI in Brazil is the identification of parallel proceedings. The third one is a draft. The third one is precedent recommendation. So AI reads the lawsuit and recommends precedents that might be applied to that situation. The result is increasing the consistency of the system because you won't have different people choosing keywords and making research that might result in different precedents. The fourth AI tool that we have is Victor. It's called Victor. It's the Supreme Court Decision Assistant. It's a groundbreaking reference when we think about AI in the judiciary. So I brought a little more information on Victor to you. The next slide, you can see the problem that Victor addresses. And to talk about Victor, it's important to remember that Brazil has a unique litigation environment. We have a caseload of more than 80 million lawsuits. It's one lawsuit for each 2.6 inhabitants. With this huge caseload, we have a lot of appeals to the Brazilian Supreme Court. They were more than 55,000 appeals in 2018, and more than 120,000 of them were ruled in that year. So to deal with this huge litigation, Brazil has established a new requisite of appeal to the Brazilian Supreme Court, the general repercussion. That is basically a requirement that for taking the case to the Supreme Court, you need to have social relevance of the appeal. Some topics already have their social relevance, their general repercussion recognized. Regarding other topics, the Supreme Court has already said that they do not have general repercussion. So instead of letting the civil servants analyze all the appeals that go to the Supreme Court, Victor, the software, was trained to do this work regarding the situations that were already defined. Victor does in 5 seconds what a civil servant used to do in 44. And more than that, Victor organizes the lawsuits that come in different formats to the Brazilian Supreme Court, separating the beginning and the end of the documents, recognizing and classifying the procedural pieces that are most important for the Supreme Court activities, and thus, besides reducing the time of the analysis of general repercussion, Victor also helps justices and civil servants in later analysis. Now, we're taking a look at the Chinese situation. China has established what they have called Chinese smart courts. Chinese smart courts, they adopt online dispute resolution tools like publicly accessible cases, like e-filings, like resources that adopt blockchain evidence storage platforms. But besides that, the AI from big data can be used to provide statistical and predictive reports, including intelligent like cases search, similar cases smart pop-ups, litigation evaluation and prediction, and judicial statistics. So in China, AI is being highly used to deal with the huge backlog and the huge litigation that they have. But the most impressive example of all is probably the example of Estonia, where a robot judge is being developed to decide small claims. Although it seems dystopic, if we think about it, it kind of makes sense. I mean, if we're talking about small claims, we're talking about lawsuits that involve not civil or political, but only proprietary rights and rights of a small amount. And we're also talking about lawsuits that usually repeat themselves a lot. So there is not much need or room for human creativity. So when we think about it, it doesn't seem to be extremely dangerous if occasionally these small claims lawsuits are ruled in the wrong way. Even because it might also happen when we're talking about human decision making. So it seems to be a good idea, and it seems to be a trend. When we look at these examples, we realize that AI decision-making in the judiciary can really help us foster some of the rule of law values, such as accessibility, efficiency, consistency. But we can't talk about the advantages of AI without considering the risks it poses. So, which one should be our points of attention before deciding by this course of action? I highlighted for you some of them, But before we address them directly, we need to understand at some level, how does AI operate? And to understand how AI operates, we need to start by a definition of algorithm. And the one I prefer is that of Pedro Domingos. It's a very simple and a very direct definition. He says, algorithm is a sequence of instructions that tells a computer what it should do. Algorithm is a sequence of instructions that tells a computer what it should do. So you have the input, the information, then this information is processed, you have the processing, and then you have the output, the result. When we talk about algorithms, we can divide them in two fundamental categories. The first one we can call programming algorithms or good old-fashioned AI. Regarding these algorithms, the programmer defines all the paths that the information, the input, will follow until the end of the processing when the result, the output, is presented. It's important to realize that although intelligent decisions are taken in this case, the software has not properly learned anything by himself. He was taught what he should do. This situation is not dangerous and we're not worried about it. We're not worried about it because what happens with the information here regarding this programming algorithms is only what the programmer has decided that should happen. This situation is not a real situation of an AI application. Our concern goes to the second category of algorithms, the non-programming algorithms, the ones that we call machine learning algorithms. And to talk about machine learning, I'm going to state again something that Chief Justice Archie said in his talk. And I'm going to remember Alan Turing, who wrote in the 50s, why instead of delivering all the available information to a computer, don't we program the computer like a brain of a child with autonomous ability to learn? That's exactly what machine learning algorithms do. They learn based on the data they're fed with. And due to that learning activity, they create their own programming. Machine learning algorithms are a technique that is spread since the 70s. And even if they are spread since the 70s, it's not until very recently that we have seen so much inventions based on machine learning algorithms. And there is a good explanation for that. If machine learning algorithms learn based on the data they're fed with, only when you have lots of data, you can have interesting results through this kind of tool. And the explanation for the traction that machine learning algorithms had recently is the advent of big data, the massive amount of information that we have. I brought to you an example of a machine learning algorithm, a neural network. Neural network is a learning model based on a trial and error strategy with gradual identification of the most correct path and decisions to reach certain goals. If you watch in your screen, you have the input layer where the information comes into the system, and then you have the output layer, the result that you intend to have. And then the system tries to go from the information that it received to the result that you intend to have. It will do this through a series of trials and errors. And when the system gets to the result that you desire, it will reinforce that path, the correct path, in the mathematical account. That's how algorithms program themselves. As algorithms learn, finding hidden patterns on the data they're fed with, as they program themselves based on these hidden patterns that are in the hidden layers that are found by the algorithm themselves, by the algorithm itself, there are some consequences. We have some difficulties understanding what happened inside, what happened in the hidden layers. I showed you before the example of the neural network with only one hidden layer. But what usually happens is that algorithms make correlations in many, many, many layers, making it really hard to the human brain to understand, when it looks at the output, the path that was followed by the algorithm. So when we look at machine learning algorithms and their result, we can realize that we must have two major concerns in mind. The first one is opacity. The second one is bias. So let's start talking about opacity. As machine learning algorithms operate in complex ways, the mere observation of the result of their operation, the output, usually does not allow us to understand the internal path that converted the inputs into the results presented. And that's why we call many times machine learning algorithms that adopt certain techniques black box algorithms. It's important to perceive that even if we're talking about an open source algorithm, looking at their code usually does not solve our problem, since the code in machine learning algorithms does not bring the rules that governs their decision, but only the instructions that command their learning activity. So if machine learning algorithms are not programmed, they don't have the internal path stated by the programmer, it does not make a lot of difference to look at their internal code. The code does not tell us the path. The path is usually the consequence of the interaction of their learning activity and the massive amount of data that they are fed with. Opacity can be defined, therefore, as the gap between the activity of the programmer and the behavior of this species of algorithm. And that is why even their programmers would not be able to fully explain the internal path towards the final decision. It's important to understand that opacity is something that is inherent to this kind of algorithm, these non-programming algorithms, these machine learning algorithms. These algorithms are opaque in the sense that the recipient of the output of the machine learning algorithm rarely has any concrete sense of how or why a particular decision has been arrived from the inputs. But how can we solve opacity? Well, a new field is emerging. It's called explainable AI. This field aims to address how black box decisions of AI systems are made, and it seeks to understand the models and the steps involved in AI decision making. But even if programmers are already aware of opacity and are already trying to solve it, we have a task that remains to lawyers, to judges, to legal operators. That is, telling these programmers what kind of information we need to understand the basic functioning of this kind of algorithm, and telling them how we want to receive this information. So this task is ours. I definitely don't want to receive a series of mathematical accounts to tell me how an algorithm works, because I won't be able to understand. So this is the job that is left to the regulators. So opacity is a problem that exists, but it's not the biggest problem that we have. Once algorithms learn based on the data they're fed with, and considering that this data is produced in the midst of the biased societies we live in, it is natural that these algorithms also learn and thus replicate this biased pattern of our societies, therefore targeting historically vulnerable groups such as women or Black people. That's what happened in the United States in the Loomis case, where it has been found by an NGO called ProPublica that a risk assessment algorithm that was being used for more than 4 years in the American state of Wisconsin was biased against Black people. So just by this, because of their race, these people had twice the chances of being considered dangerous than, for example, white people in the same situation. How do we fight bias? Bias is usually a silent threat and a very hard one to identify. And the point is that even when we find discriminatory patterns on data, the way forward is a challenge. What should we do? Should we message data to make things better? If yes, how? Should we, for example, create a fake data set to try to reduce bias? Should we multiply the number of people in certain categories to try to get to gender equality or racial equality? The strategies adopted might be different. The results are different. That is not a correct answer for this question. We have an ongoing discussion with multiple stakeholders in which multiple stakeholders might be involved. So bias is a situation that is different from opacity. Opacity, we can see the end of the line, we can see a solution in the horizon. For bias, the situation is much more difficult. But there's also a positive side of AI when we talk about fighting bias. That is, with AI, we have an opportunity to deal with the opacity and the implicit or explicit biases of human decision makers. These biases of humans can be much harder to find and to root out than computational ones. So AI can make the situation better than it is today. Going to the end of the presentation, we should discuss the question of the regulation of AI. This is not an easy question. We have a lot of doubts on whether we should or should not regulate AI. No one wants to kill innovation, but at the same time, we must be aware and we must take safeguards to deal with the risks AI is posing. Brazil has a bill. Brazil has just started a bill to try to regulate AI. We had already a lot of discussions, and we're getting to the conclusion that more interesting than regulating AI in general is to have sectorial regulation. In Brazil, we already have this kind of sectorial regulation for the judiciary. The National Council of Justice has regulated the application of AI in the Brazilian judiciary. So regarding ODR tools, they have stated that until the mid of next year, all the Brazilian courts should have their own online dispute resolution system. And concerning AI tools, they have stated some general comments regarding the necessity of interoperability of the tools that the courts adopt, to avoid that they adopt tools that might be applied in one court but not in the other one. It's a way to rationalize the job that is being made. They have banned tools that would make risk assessment due to the Compass example, due to the Loomis case. They have banned AI applications on the criminal field, and they are starting to establish some safeguards regarding data protection. That is what feeds AI tools. So the scenario of the regulation of AI is this. It's interesting to have a sectorial regulation, and it's important to target what we already see as its biggest dangers. So, going to the conclusions, when we look at AI in the judiciary, we can see that these kind of resources are being seen as a way to deal with the litigation, the increasing litigation that we face, with the huge backlog that Brazil faces as well as other countries. And technology is being seen as a very important resource to deal with all of this situation. So in the scenario of ongoing change and looking at the future of the judiciary, the fundamental question to the world does not seem to be whether we are integrating technology into the judiciary, but where and how we're doing so, and also the safeguards that we must take. In this discussion, you play a central role. I call you to use your voice. Thank you.
Thank you very, very much, Judge Ferrari. I'm sure that our listening audience will agree that this has been a very, very enlightening, comprehensive, and yet easily digestible discourse. It's given us lots of food for thought, and I'm sure that there are many questions from the audience. Let me remind the audience before we move to our break that the platform is open. You will see that there is an email link that should be flashing across your screens on a banner to which you may submit your questions. We will have a look at the questions and we will have a curated Q&A at the end of the break in the form of a sort of fireside chat between myself and Justice Ferrari. Don't worry if you don't get your question answered during this time. Time is limited. We will be looking at all of the questions and trying to answer as many of them as possible by way of email. May I just hand over to Dr. Francois for some quick house announcements.
Thank you very much, Chief Justice. Good evening, attendees. I know that our break is short. I am just providing you with a quick reminder to complete and submit our distinguished jurist lecture session evaluation form. The link to the form will be posted on the judiciary's Facebook page as well as on the judiciary's website. It is important that we obtain your feedback about today's lecture. Thank you and continue to enjoy the program.
Thank you very much, Dr. Francois, who is our judicial educator. Thank you very much for your house announcement. Just to tell everyone, it's now 6:15. We'll be taking a 10-minute break. Please, I invite you, don't come off any of the live streaming platforms. What you can do is use it as your stretch exercise because I'm sure you want to engage and really enjoy the session that is upcoming. And we will resume promptly in 10 minutes. That will be 6:25 p.m. So remember to be in front of your screens again, 6:25 p.m.
Thank you and good evening again to all of our listeners. During the break, we've had some extremely interesting questions, and the biggest challenge to me is not to find good questions, but to pick which ones I think would be of most general interest. Judge, in no particular order, I would like to start by asking one of the questions which I think we are all wondering about. And the question is framed this way. On the point of fighting AI bias, it should be noted that differential outcomes are not necessarily indicative of bias. We get them all the time in your judicial decision as well.
Mm-hmm. Yeah.
Has this been considered during the discussions on combating AI bias?
Yes, it does. Actually, you There are two different situations that can result in bias when we're talking about AI. The first one is when you have incomplete information, and then you have systems that do not work well for specific categories of people. I'm giving an example that is not in the legal field, but that might make this situation more understandable. So during the pandemics, we had done a lot of research using AI in Brazilian hospitals. Of course, it's much easier to use information when you have electronic electronic files of the patients. Electronic files are something that you usually have available in hospitals that are accessible for a part of the population that is richer. If you train your algorithm with this information and you do not take in consideration the information of other people that usually do not have access to these kind of hospitals, you can have an algorithm that does diagnosis or prognosis that works really well for that kind of population that has access to these rich hospitals, and an algorithm that does not work properly with a population that has characteristics, um, for a population that has that does not have access to this kind of hospital. I mean, you can have differences in race, in the ethnical uh, component of this population, and then you're going to have an algorithm that works well for one and differently for the other one. And the second situation that can entail bias is this situation where the data is biased due to the characteristics of our societies. And we can have biased data, I would say, in two different situations, and that's where the answer to the question starts. The first one is when there is indeed bias behind that decision. For example, if there is a racial or a racial component on a decision that I give due to my implicit bias. In the second situation, that is what's more difficult, is when the data is perfect, but the data reflects a situation that we want to change. What should be done in these cases? This is very difficult. I always talk in my classes to my students about algorithms that you can use to choose employees for your company. If you want an employee that has the profile of becoming, for example, a CEO, what would you use as a training data to this algorithm? You do use the information on the CEOs that already exist. But if we take the profile of a CEO that exists nowadays, in Brazil, we're going to find probably a list of white men in their 60s. If I train an algorithm with this information that is perfect, it's correct, it reflects the reality, I'm going to stimuli a status quo that we want to change. So this is the biggest challenge, when the information is correct, but when there is like a structural situation behind that. What do you think about it, Justice, Chief Justice? You're muted. You're muted. You're muted, yes.
Sorry, you're perfectly right. And as you were speaking, it occurred to me that a question that follows is, what types of cases would be suitable for um, resolution by AI? And can AI actually act as an inhibitor to the development of the law? Do you have any thoughts on that?
Exactly. I think that the question, as I stated in the end of my talk, is not whether we're adopting AI. We need to adopt AI due to the litigation, the backlog. We need to adopt AI because law firms are adopting and we're going to have a lot of lawsuits to deal with. But the point is, where is it safe to adopt AI? Where do we want that? Even if a mistake is made, this mistake is made by a human and not a software. I think that for example, in criminal fields, we should avoid this kind of tool, for example. And this is why it's so important to discuss these issues and to understand not only the opportunities that AI brings, but also the risks.
Would you say that on the question of bias, it's easier to detect and address AI bias than human bias?
Definitely, I think it is. I mean, you can find statistically this kind of bias. The bad news is that you can only find bias in AI when you have, for example, a lot of results. Mm-hmm. If you're a careful person, you're going to make tests for a long time before implementing AI tools. If you're not, you're going to see exactly what happened in Wisconsin with the Loomis case, where they started to use the software, and after a lot of people were ruled using that information, then they found out that there was a bias pattern, and it was not even the judiciary, it was an NGO that did this job.
So it comes back to the observation I made at the beginning, that the quality of your data set is critical in determining the value of AI and assisting you. And so my question then would be, to whom do we assign responsibility when things go wrong?
This is the difficulty of AI. I mean, these are the discussions that everyone is taking right now. And I would say that this is the key discussion exactly because of the characteristic of the opacity that we talked previously. So if we could really understand what is behind the functioning of AI systems, this wouldn't be difficult. But as we can't properly understand, this is something that appears as a problem. But the good news regarding opacity is that this is already beginning to be solved. I mean, the explainable AI field is a field that has grown a lot in the last 2 years. So we're already envisioning the light in the end of the tunnel. This is something that we're already envisioning. I mean, in the near future, we'll be able to understand what happened there. Bias, and on the other hand, is a much more difficult situation because even when we look at the data, it's not obvious when the data is biased. And that's where the human comes. And that's where we have to open to multiple stakeholders, because on our blind spot, someone else, a different group, can bring new information. That's why what I always say when people start questioning whether lawyers are going to win, judges are going to win, no, there's always space to the human, because the intelligence comes from the human. The computer, as we have seen, learns based on the data it's fed with. When you learn based on data, you're learning based on the past. When you're learning based on data, you're not reasoning. Computers and softwares, AI, does not reason. It just replicates previous knowledge. So we'll always need this critical take of humans to realize that these problems exist and to think about how we can solve it.
I suppose that answers in part the next question I was going to ask, which is a very interesting one. Do you perceive a tension between AI and EI, that is emotional intelligence, which is a requirement of a modern day judicial officer? If so, is there a way to resolve that?
No, I don't think there is any tension at all. I think that AI is doing for us what computers did for us in the 90s. I mean, it's making our lives easier. We're using AI to help us have free time to use our intelligence to what really needs it. So if we can't automate things, we're going to do that, but there will always be those difficult cases, those cases that demand a different answer from everything that we have already seen. And I would say that in this world that we're living, that is facing an ongoing change, in this world that has a lot of unanswered questions, human agency will be very, very important. AI will give us time to think deeper on that questions that really demands human intelligence.
We're shifting away a little bit to another issue which I think concerns a lot of people, and this is the question of whether criminal and or civil responsibility can be ascribed to the owner of an AI that causes an offending act, whether negligently or in pursuit of its functions. And I'm thinking particularly here of recent examples we've had of self-driving cars running down pedestrians. What's your thoughts on that?
I don't think, at least in the Brazilian legal system, it would be possible to ascribe criminal responsibility at all, but civil liability definitely. And the situation is not much different from what we already have. I mean, if you were run over by a self-driving car, or if you were run over by a car that was being driven by a child or an alien or anything, I mean, the answer is always the same. I mean, you have to be protected, and the person that is answering for what happened is the one that created the risk. The difficulty with AI is not to protect the person that has suffered the damage. The difficulty with AI is to share the responsibility among those involved. So will we make responsible the person that has developed the AI system, the person that has created that self-driving car, or the person that has bought that self-driving car? And to answer this question, we need to see the specifics of the situation. So, for example, if the company that has built the self-driving car has told the owner that he should, for example, refresh the software each 2 months, and he hasn't done that, it's his responsibility. If there's a problem with the software, it's the responsibility of that the person, the agent that has produced the software. So I don't think that civil liability is such a challenge as it's posed. But of course, like the criminal matter is a difficult one, because I don't see how we could describe it to anyone. But we can't also put the AI in jail, so nobody is answering the criminal field. I don't. It's a difficult question, this one.
I'll come back to the putting AI in jail because I have an interesting question on that score. But I just want to tell our audience that what we're discussing here is not so far-fetched. Back in 2015, a software engineer named Jackie Alcine realized that Google algorithms were classifying his black friends as gorillas. Now, of course, Google claims to have fixed the problem by blocking certain image recognition algorithms. But the self-driving cars are actually trained on Caucasian faces. So in a situation like that, the question one has to ask is, shouldn't the programmers be responsible? Because you are feeding and selling a flawed system to both the car dealer and the purchaser, who have no idea at all of what is going on in your algorithms. But on the question of moral responsibility for being assigned to AI, I know that in places like South Korea, for example, they have been working for some years now on developing ethical standards for human AI interaction. And so one of the questions posed by our audience is this: in what circumstances can AI be subsumed under the definition of legal person? After all, we are already assigning legal personality to trees and forests and rivers.
I just wanted to go back on something that you said before.
Yeah.
You were talking about the Google and the Caucasian faces, etc.
Yeah.
I wanted to talk about a situation that was very known after it became the topic of one of TED Talks, is what happened to Joy Bolamini. Joy Bolamini recorded a TED Talk talking about what happened to her. She is a Black woman. She is a programmer. While she was finishing her graduation in the UK, she was assigned a task to create a social robot. She decided to create a robot to play peekaboo. I don't know if you're familiar with this kind of thing. It's not something that we have here in Brazil, but peekaboo is just a game that you play. You look at another person, you cover your eyes, and then you uncover and say peekaboo. So what she needed to do was to create a social robot that saw people. It just needed to see human faces to be able to play. She used an open source software, and she realized that it wasn't working with her. And she soon realized it wasn't working with her because that open source software, that open code software, wasn't able to recognize faces of Black people. She ended her assignment, and then she moved to the United States. She went to do her doctoral thesis at MIT. And while she was at MIT, she was part of a competition in Hong Kong. When she went to Hong Kong, they took the participants of the competition to get to know the scenario of the startups. And she had the same problem again with social robots. They couldn't recognize her face. And by that time, she already understood what the situation was, what the reason was. But she was really surprised to get to know that the open code software that was used in Hong Kong 4 years later was exactly the same one that she used years later at England. And let's think about it. If she wasn't a Black person, she wouldn't realize that it was not working with her. She used an open code software. She wouldn't realize the problems it might cause. And she would be like multiplying the problem without knowing, without having agency on that. And that's why it's so important to regulate, to say, you must take care with this, this, and that, in a way that if the developer does not take care in having a data set that reflects humanity, he will have problems. But before assigning him liability, you need to tell him this might happen. We have a blind spot here, because it's something that is so new that we haven't realized exactly all the problems that might happen. So going to your question specifically, in which circumstances AI should have legal personality, etc. What I can say is that in Brazil, 99% of the professors deny the possibility of assigning legal personality to AI. And this has been a trend in Europe in 2017. But since 2020, they have abandoned this position. They think that we still do not have a technical level of development that that justifies that we assign legal personality to AI. That's what I think too.
Yeah.
I think perhaps we could go with, if the concern is with the damage that AI may cause, instead of assigning legal personality, they could just establish a mandatory insurance, for example. It seems to be an easier suggestion.
Yeah. I think for my part that the question of when does a particular level of neural complexity achieve sentience is still open. I think one of the things that we know for sure is that any prediction about the development of AI that we make beyond a 5 or 10 year horizon is going to be drastically wrong. So I think we leave that one open for the time being. The other question that I thought we might tackle is how do you deal with the feeling of litigants that need to assert the truth? In other words, when we do mediation, we try to deflect that desire. I want to see who's right, or to prove that the other side is lying. And we try to deflect that by focusing on the future concerns and interests. Is there a way that online tools can help here?
I think if online tools tell you that by not getting to an agreement, you're going to stay with your lawsuit ongoing for like 20 years, and in the end of the day, you're going to receive the amount of, I don't know, $3,000, and you have a proposal of solving your problem in like 1 month and receiving $500, I would take the 500. I think this is something that can help. But of course, when we talk about mediation through softwares, we're talking about a situation where you take off the human component trying to push disagreements. This, when we talk about claims that involve only proprietary rights, does not seem to be a problem. But when you have sensitive situations, this might not be an intelligent strategy. When you have a situation where you lost someone you love, where there was a great tragedy, then you need to design a system where the emotional component is also worked, as well as the monetary part of it, I would say so. So designing a system is not something that is a given. It's something that you need to think specifically to address that kind of conflict that you have. If you design a system in the wrong way, you won't have the results that you need. The National Council of Justice asked me some time ago to think about an ODR system to address big tragedies that we have here. We had an environmental problem, a massive environmental problem in Brazil, with a lot of life is being lost, a huge problem. And one of the things that I said is that you have to have an initial moment in where you give attention to the emotional component of the conflict, where people can talk about their losses, the people that they lost, where they can talk about who these people were, in a way that after working the emotional component, they be free to start talking about the practical things that this conflict involves. But if you try to go to the practical before the emotional one, you won't get where you want to.
Understood. I suspect that in Brazil, as in many small island developing states, the question of the internet connectivity divide is something that you've had to consider. How do you approach it where there is not universal access to internet connectivity? Is there a way that Brazil has dealt with this problem?
So Brazil actually has a good situation when you think about internet connectivity. It's very interesting because 70% of the country, of the people in the country, have access to a smartphone. We have more people with the smartphones in Brazil than people with sanitation. This is crazy. But the point is that we have 30% of the population that does not have access to this. So what we should do in this case? The first thing is to realize that these people that do not have access to smartphones, they would probably be away from physical courts as well. They wouldn't have the information to know where they should go. They wouldn't have the information on the public defendants that they might ask help to. They wouldn't go even to physical courts. But this is not the answer we want. We don't want to say, let's do the digital transformation because these people are already excluded. We want justice to be offered also to them. What I see is the possibility of a multiple stakeholder organization in order to help with that. So if you think about Brazil, you have the bar associations having you have buildings of the bar association in all the cities. And I would say that if the judiciary, the bar association, the public defendants, the public prosecutors, they work it together to try to create a structure in the community centers, things would be much better. I mean, that's what we're thinking about. If you have a community center, if you can have 2 or 3 computers, if you can have like a public defendant, if you can have a community leader there explaining to people how they can demand that their rights are respected, you can advance a lot. And it's much more, it would be like a bigger advance than simply providing free internet to all, because at some point, it's the question is not the access to internet. The question is the information that you have.
We have, in the context of moving courts to operate online as opposed to online courts in Trinidad and Tobago, begun to address that access to justice problem by having virtual access virtual access customer centers throughout the community.
Perfect.
So yeah, I suppose that that is something that will have to grow. We provide customer service assistance because the people who don't have the technology also have a challenge navigating the technology and of course the court rules. So I think the responsibility will lie with the state to ensure that there is not a differential access to justice.
Yeah.
On that score, has the adoption of AI changed the composition and size of the court's labor force in Brazil? How has that impacted?
The adoption of AI has allowed us to produce much more than we produced previously.
Okay.
But the point is that each year we're receiving more lawsuits because AI is not only in the judiciary, AI is also in the legal firm. So the input of the system is increasingly in a crazy way. So the output needs to be bigger. But more than that, we're working in the two ends. I mean, in the output, trying to produce more sentences and decisions, etc., but also trying to reduce the litigation to avoid that the cases are open. And that's where ODR comes into the game.
Okay. Great. I think that those are the questions we have. We were assigned to 35 minutes for this aspect of the talk. There are other questions which, of course, have been put up on the platform, and as I said before, we would be addressing them. I want to thank you very much, Judge, for not just for your lecture, but for the very engaging and enlightening way in which you have addressed the questions that we have asked. I will give you 2 minutes before handing back to the chair. If there are any final thoughts or observations that you wish to leave with us, we'd be delighted to hear from you.
I want to thank you so much for the invitation. I want to say that it's a pleasure for me to be here. I would like to thank all of those who put so much effort in making this event happen. I'd like to thank especially Justice Lucky, Samantha Ford, the coordinator of the Institute, Ms. Teresa, Avery, Tenerife, that helped me with the electronic questions. I talk about a lot about technology, but I'm not a very technological person. And I would like to say that this kind of discussion that we're having here is so important. And Trinidad and Tobago is so lucky to have you as a leader in this field. I'd like to thank everyone that listened to me, and my email is there. If there are remaining questions, I'll be happy to answer all of them. And that's
Well,
what I said. Everyone here is a very important agent in this multiple stakeholder take that we have. We've seen that technology brings a lot of opportunities, but also brings some dangers if we want to have a good transformation, a transformation in the sense of reinforcing the rule of law values. We definitely need to engage in this kind of discussion.
thank you so much. We receive your thanks with appreciation. And to thank you properly, I will now ask Madam Justice Charmaine Pemberton to take the mic.
Thank you is such a prayer that cannot be seen or touched. It must be felt by the heart. Honorable the Chief Justice, Mr. Ivor Archie, ORTT, and Mrs. Denise Rodriguez Archie, Justice Isabella Ferrari, Federal Judge, Federal Regional Court of the Second Region, Brazil, and the 2021 Distinguished Lecturer of the Judicial Education Institute's lecture series. Other distinguished participants, good evening. I beg your indulgence in the interest of time to adopt the established protocol list. It is my singular honor and privilege on behalf of the President and Chairman and Board of Directors of the JEITT to move the vote of thanks on this memorable occasion of our 9th Distinguished Jurist Lecture. And it is important to note, the first ever to be held virtually. Justice Isabella Ferrari has taken us ever so adroitly on a journey demystifying views and perspectives related to artificial intelligence and its interconnectivity with the justice system. Together, we have been able to interrogate crucial questions related to this area and forge new intellectual concepts and conceptualizations in this dynamic field. For those who have been attendants, we look forward to seeing you at our 10th DGL in 2022, in whichever forum is allowed, hopefully face-to-face. To the Honorable the Chief Justice, our President and our host today, we thank you for your transformational vision for our judiciary, your adherence to the judiciary's mission by forward-thinking leadership continues to serve as a compass as we navigate these ever-shifting, but I dare say exhilarating tides. Law and judicial behavior traditionally has been classified as reactionary, needing some form of stimulus, sometimes shocking, so as to produce action. And so to our distinguished jurist lecturer, Justice Ferrari, we express our gratitude to you for your erudite and comprehensive lecture. Hitherto, some of us recognize hesitantly and sometimes grudgingly that artificial intelligence is the agent of change or the embodiment of change itself. But I am sure you will agree, audience, that Justice Ferrari has left us intrigued by sharing her thoughts, and by so doing has convinced us that there is no turning back the hands of time. Madam, you expanded our knowledge in the field, and we are so much better for it. Thank you. To our moderator, Honorable Justice of Appeal Gillian Luckey, our chairman, thank you for guiding us through this evening. Your vibrancy kept us on our toes and thoroughly engaged. We appreciate all that you have done for judicial education. An initiative of this nature does not happen overnight. The wheels begin turning, heating up the engine room months in advance. To the management team of the JEITT, ably led by Dr. Carissa Marie Francois, judicial educator, and comprising Ms. Samantha Ford, coordinator, Ms. Tricia Dasrath, Judicial Research Council, and all members of staff, thank you for the hard work you invested to ensure today's success. To Mr. Carl Francis, Court Protocol and Information Manager, Mr. Avery Hiralal, Senior Audiovisual Technology Specialist, Mr. Jassy Adams, Senior Corporate Communications Officer, Mr. Tenerife Mapp, ICT Technical Officer, and all other members of staff, Darius, who provided support to the DGL. Thank you for your commitment. None of this could have been completed without your guidance and expertise. In closing, it gives me great pleasure to send a big shout out to all of our wide and varied participants and attendees who joined us in this space. That's how we call it now, it's space. The Chancellor, Chief Justices, and other heads of judiciaries and tribunals, judges, judicial officers, parliamentarians and assemblymen, attorneys at law, academics, justice sector stakeholders, the media, representatives of professional bodies and associations, all of you who I collectively term our partners in justice delivery. Your presence has indeed added flavor, and of course your questions that were so piercing to today's proceedings. And we hope that you will continue to support all of our future endeavors. Stay safe and do take care. From all of us at JEITT, thank you, thank you, thank you.
And thank you very much, Justice of Appeal, Madam Charmaine Pemberton, who is also a very hardworking member of our JEITT board. Thank you for all that you have done also behind the scenes, ensuring that that engine room continued to operate at an optimum. And as I now turn over to the person who will be doing our final remarks, I just want to say a big shout out to Asha and Sharisa, Shea, Amos, and Camille, because they too have been in that engine room, just moving and helping everything come to what we have today, which is a fantastic platform. I hand over now to another hardworking board member of our JEITT, and that is Justice Narala Bansi Sukai. And Justice Bansi Sukai will give us now our closing remarks.
Good evening, attendees. As we conclude the 9th Distinguished Jurist Lecture, there are 3 brief announcements. Firstly, I know that many of you have submitted questions based on the very interesting and thought-provoking lecture we all heard this evening. However, due to time constraints, some of the questions may not have been answered. We have good news though. Those questions that were not answered will be forwarded to our distinguished jurist lecturer, and the responses will be sent to you by email. Secondly, the judiciary recognizes the attendance of our law students at this evening's event and is pleased to be a part of your orientation as you prepare for your life in the legal field. And finally, those of you who have completed your evaluation forms, we thank you for your feedback. And we look forward to the feedback from those of you who have not yet had the opportunity to complete your evaluation forms, as the form is still available on the judiciary's Facebook page and the judiciary's website. We thank you for your participation and look forward to your attendance at future events. Do have a safe and enjoyable evening.